Why should all buyers perform a final walkthrough? And when presented with an amendment to address concerns, should the seller agree to make repairs or simply attempt to negotiate a reduction in the sales price?
Welcome to the Real Estate Game Plan Podcast, where we bring you inspiration, actionable steps, and knowledge to build your game plan to take your real estate business to the next level. My name is Demo.
And I'm Derek, and we are licensed real estate brokers and your hosts for this podcast. Let's get started.
Hello, Solid Source. I'm Derek Varnadoe, Vice President of Broker Services, accompanied by
Heema Patel. I'm one of the attorneys here and member of the broker staff here.
Heema, we're so glad to have you on with us today, and we're sharing proactive tips to avoid those last-minute closing delays. So our very first topic is deeds. So a copy of the deed at the time that we take a listing or when we are preparing an offer helps to confirm the legal description of the property, but it does much more than that.
I love having to pull deeds. This is my bread and butter. This is what I'm passionate about. I think it's very important for agents to pull the deed before taking a listing or before going under contract, simply because it confirms a few things for us. First, it confirms that you have the most recent legal description. It verifies ownership of the seller. And 3, it allows you to get ahead of the title issue if there is one that may be in existence. For example, if there are 2 people on title, and only one person has signed the exclusive listing agreement, or there's only one person to sign the contract, that should, set you off to think, okay, well, what to do about the second person that's on title? There are a few ways to get around that, or not get around that, but simply to address that. And one thing is to know the difference between joint tenancy with right of survivorship and tenancy in common. When 2 people take title as joint tenants with right of survivorship, if one predeceases the other, the surviving spouse or the survivor takes full ownership of the property. If, however, there's no joint tenancy with right of survivorship language in the deed, then most likely it's tenancy in common, in which case if there is a person who's missing or signature that's missing, you have to first find out the status of the person that's not on, that hasn't signed the contract, and figure out if maybe a probate is needed, or there was a divorce perhaps, and it allows you to kind of get ahead of that title issue.
Right. So for example, let's say an individual reaches out to us to list their property, and they disclose to us that their spouse has previously passed away, and we receive a copy of that deed. What are some things that we might want to look for on there? Because you had a great point. If they're joint tenants with the right of survivorship, no action is required. That ownership will automatically flow to the remaining partner. But if they were joint tenants, or perhaps it's someone, maybe it's sole ownership, and they've passed away with a will or maybe without a will, does it still need to be probated?
It may, and that's definitely a question to ask, your seller or your owner, just because they may have already gone through the probate matter, and it's just a matter of conveying the deed out of the estate, or perhaps they died so long ago that, there's maybe another avenue to clear that title issue. But it's definitely something to address ahead of time, so that way it doesn't delay your closing when you finally get to it.
True or false? Testate versus intestate. Testate is if someone passes with a will, and intestate is when someone passes without a will.
True.
Yay! So let's move on, Heema, and talk a little bit about offers and contracts. So really important, I feel like, when we receive a cash offer, that we see those proof of funds. I think it's a little bit of a red flag if we receive an offer that we are presuming is cash because there's no financing contingency, and they don't have proof of funds.
Definitely. Whenever there's a cash offer, I always recommend getting proof of funds, either an account statement or a letter from the bank showing that this person has the ability to purchase this property at this offer.
And if it's financing, so much better to have a pre-approval versus just a pre-qualification. With a pre-approval, a buyer is having to go ahead and provide important documents to a lender up front, and they're going ahead and they're reviewing those documents. It's pretty easy to get pre-qualified. Most of us can do it simply online. So a pre-approval is definitely a much better way to go. And one question that can sometimes come up talking about cash deals is if a buyer doesn't have proof of funds because they're looking to sell another home, but they aren't including the sale or lease of buyer's property contingency exhibit along with the offer, How do you feel about that?
I think it's very, very important whenever there's another sale that's happening to definitely disclose that to the seller and make that contingent on that offer. Otherwise, your buyer is going to potentially breach, and your seller is going to lose out on time and money and effort that that they've gone under contract for.
And a good point too I'd like to make is if it's financing and the sale is still contingent on the sale or lease of another home, but that sale or lease contingency is not included, the buyer would be at risk of losing their earnest money.
That's correct. Yeah.
Some really good points. I do want us to also discuss a buyer's change of financing. Let's say, for example, a buyer goes under contract with a seller with a conventional loan exhibit, but then they switch at a certain point over to FHA, VA, maybe even USDA. Can a buyer do that?
Technically, no. The buyer cannot just switch from a conventional to an FHA to a VA without having an amendment first. So I always recommend get an amendment if you're going to switch financing. You have different rights under an FHA contingency or a VA contingency than you would on a conventional. And you don't want to breach as the buyer by failing to do that and then also seek FHA and lose your earnest money.
Correct. And it's really per the conventional loan contingency exhibit itself. There is language on the form that specifically states that if the buyer is going to do that, that an amendment would be required. And really, it's just a good practice because also if you're switching from FHA to conventional or VA to conventional, the buyer wouldn't be protected unless an amendment was done to incorporate those new terms.
Correct.
Why is more earnest money helpful? Why is it that we hear the more earnest money a buyer puts down, the less likely they are to walk away? And also, why is it important for a seller?
Well, I think the reason it's so important for the seller is under the GAR contract, that is the seller's sole remedy is the earnest money. And when it's just another extra layer to protect the seller when there's increased earnest money because it's less likely that the buyer is going to walk when there's so much money on the line.
So more earnest money because it's the seller's sole remedy, and more earnest money because the buyer is less likely to simply throw in the towel if things aren't going in their favor. So I do want us to also discuss amendments to address concerns, repair requests, because first off, Seth does a really great job of this, but explaining that GAR's intent for the amendment to address concerns is not for it to be a laundry list of repairs, but to address very specific key items that a buyer simply couldn't live with and wouldn't want to purchase the property if they weren't corrected. So what is some advice that you would offer to a seller when they receive these amendments to address concerns?
Well, I would recommend either taking a reduction in price in lieu of repairs so that there's not, issues with closing, and determining whether those repairs were done correctly or there's not a dispute as to how those repairs were done. So oftentimes I do recommend that sellers lower the purchase price in lieu of repairs. And if they're going to do it, pick the most significant ones or pick the ones that, actually matter to the buyer. Because as you said, it's not supposed to be a laundry list of items to repair. It's supposed to be those things that are really of a concern for a buyer.
Those are some really good points. And also on the amendment to address concerns, it is really important that it be signed and delivered back to the buyer before the expiration of the due diligence period. It's not enough to simply have that amendment sent over to the seller. You would want to have everything signed off on before the expiration of due diligence because after that, the buyer is presumably purchasing the property as is. Final walkthrough and issues post-closing. So every buyer, I can't imagine a buyer that I would not recommend that they perform a final walkthrough for a couple of reasons. One is the GAR contract does state that the seller will deliver the property in substantially the same condition as it was on the binding agreement date. Of course, taking into consideration any repairs that the seller agreed to make. And if the seller did agree to make repairs and we are working with the buyer, we really want to make sure that those repairs have been completed.
Yes, Derek. And just a few things to add with the final walkthrough. The reason it's so important is it allows the buyer to really gauge whether those repairs were done correctly or to their satisfaction ahead of time or per the amendment to address concerns. Second, it allows you to look at the condition of the property when the seller moves out, hopefully by then, because, maybe in the initial inspection, you weren't able to view everything. You weren't able to see everything. And, the sellers, now that they've moved out, things are removed, you could see better condition of the property and address anything that may need to be done at this point. And then third, everything that the seller said that they were leaving the property, you want to make sure that it's actually there. Fixtures, refrigerators, really anything that was already stipulated and disclosed as needs to stay in the home. And that's a great opportunity for the buyers to check to make sure that actually has happened.
A question that oftentimes comes up is, does a buyer have a right to access the property, inspect the property, have their professionals access the property after the due diligence period has expired?
Absolutely. Buyers do have the right to access the property, of course, reasonably. So they can ask the seller, and they do have a reasonable expectation to access the properties, to allow contractors to access the property, and the sellers cannot unreasonably deny that request.
Now, how should we handle, as agents, any issues that may come up post-closing? Because what we know is that our duties to the parties, and really our ability to be able to jump in and effectively help the parties, is going to end at closing. But there are times when issues do come up post-closing. What is some advice that you can offer us in terms of how to handle that and how to best advise our clients?
Well, Derek, I would always say, I agree with you that the agent's duties to the client do end at closing. There's not much that the agents can do to enforce anything post-closing. Of course, as a courtesy, if they could try to get in touch with the other agent and try to coordinate something with the seller if they needed to, in terms of any repairs that may need to have been done, or contact information for any contractors or anything like that. However, they don't have a duty to do that. And sometimes, unfortunately, the buyers, it's a buyer beware state. So at the end of the day, you do have to make sure that you protect yourself as well.
Absolutely. And if there are repairs or any items that can't be completed by the date of closing, moving the closing date back usually leads to happier buyers and sellers, even instead of a temporary occupancy agreement for seller after closing. If we could simply just move that closing date back, that's typically going to be the better way to go. How do you feel, Heema, about escrow agreements if, let's say, that the parties wish for the seller to cover items after closing and withhold a certain portion of the seller's proceeds?
So the guard definitely has an escrow agreement in place. So there is that option available. However, I don't recommend using an escrow agreement. I think it just it invites disputes after the closing if there are any repairs that are not done to the buyer's satisfaction. And then there's always a question of, to whose satisfaction is the repairs? And of course, the lenders and the closing attorney has to agree to be able to hold that money in escrow and allow that to happen. For a lot of lenders, that's not acceptable. They do require repairs to be done, prior to closing. And therefore, there's no disputes after closing.
Well, Heema, I am so thankful for you spending time with us today and helping us to address some of these questions and concerns, these tips for avoiding last-minute closing delays. We appreciate you so much.
Thank you, Derek. I'm very excited to be here and to help with anything you guys may need help with. So I'm only a phone call away.
Well, thank you again, and thank you all for watching. We hope that these tips help. Until next time, have a wonderful day.
You've been listening to the Real Estate Game Plan Podcast. Don't forget to like and subscribe on YouTube and leave us a 5-star review on your favorite podcast platform. Thank you for listening.